and welcome back to another episode of Courts This Week presented by LiveLaw. I'm your host Ostika Das and I'll take you through the most significant courtroom developments from this week. From the Supreme Court to local courts, I've got you covered with crisp and clear summaries. But for a deeper understanding, I will always encourage you to check out the news articles available on our website www.livelaw.in. In today's episode, we are going to talk about the Women's Reservation Bill, the legal development related to Udhayanidhi Stalin's comments about Sanatan Dharma, the Adani-Hindenburg legal saga and much more. So let's dive into the headlines. We begin with a significant constitutional development. On Thursday, the Rajya Sabha unanimously approved the Constitution 128th Amendment Bill 2023, which proposes to reserve one-third of seats for women in the Lok Sabha, state legislatures and the Delhi Legislative Assembly. The bill was passed by the Lok Sabha with a two-thirds majority on Wednesday. This marks the latest effort to pass such a bill, with the previous attempt in 2008 lapsing after the dissolution of the 15th Lok Sabha. Now, the new bill amends Article 239AA of the Constitution to enable 33% reservation for women in the Delhi Legislative Assembly and introduces Articles 330A and 332A to introduce similar provisions for the Lok Sabha and the state legislative assemblies respectively. Notably, Article 334A contains a sunset clause saying that this policy of affirmative action will come to an end after 15 years from the date of the bill's commencement. While this is no small victory for the legislators from different political parties who have been advocating for women's reservation for decades, this bill will only come into effect after a delimitation exercise following the first census conducted after the bill's enactment, owing to the operation of another article that the bill introduces, which is Article 334A. The government has also clarified that this bill will not be implemented before the upcoming general elections in 2024 and it might not get enforced at all before 2026. During the discussion in the two houses of the parliament spanning over 20 hours, opposition leaders broadly supported the Women's Reservation Bill but questioned the delay in implementing it and raised concerns about the need for a census and delimitation exercise before its enforcement. They also advocated for including women from other backward classes within the women's quota, just as up to one-third of the seats have been reserved for women from scheduled castes and scheduled tribes. Some political parties also urged the government to introduce horizontal reservation for women from minority communities. Some others requested the union government for women's reservation in the Rajya Sabha and the state legislative councils in states that have a bicameral legislature. But despite the reservations and concerns raised by political parties, the Women's Reservation Bill was passed with broad bipartisan support in both the upper house and the lower house of the Indian Parliament. Let's begin discussing the developments in the Supreme Court with an update in the Bilkisbanu matter. Oral arguments are nearly complete, with the lawyers representing the 11 convicts prematurely released last year by the Gujarat government having concluded their submissions this week. The Supreme Court has adjourned the hearing until 4th October for the petitioners' counter-arguments. During this week's hearing, senior advocate V. Chidambaresh, representing one of the released convicts, argued that remission orders can only be challenged in high courts, not the Supreme Court. He pointed out that Article 226 of the Constitution, granting high courts the power to issue writs, is broader than Article 32. Another lawyer challenged the Supreme Court's authority to overturn the remission order on the ground that a fundamental right cannot be invoked against another fundamental right. He emphasized that once remission is granted by the competent authority following relevant policies, the right to life and liberty accrues in favor of the convicts. He stressed the importance of safeguarding the rights of both victims and the convicts, especially considering that the convicts have already served 15 years of their sentences. The counsel strongly insisted that once remission is granted in accordance with the applicable rules and procedures, the order should not be disrupted. Tamil Nadu Minister and CM M.K. Stalin's son, Udhayanidhi Stalin's recent comments on Sanatan Dharma have stirred controversy. He allegedly suggested eradicating Sanatan Dharma instead of opposing it, comparing it to combating diseases like dengue and malaria. Several pleas have been filed in the Supreme Court, all seeking action against the DMK leader. This week, a bench headed by Justice Aniruddha Bose agreed to issue notice in one of the pleas, which was filed by a Chennai-based lawyer, seeking the registration of an FIR against Udhayanidhi. Besides this, The petitioner has inter alia also sought constitutional authorities from being restrained from making such provocative speeches targeting one community. Although initially hesitant to hear the case, the court eventually agreed to hear it, but it refused to combine the matter with the other hate speech cases for now. In parting, Justice Bose also expressed his disapproval over litigants approaching the Supreme Court directly. "You have turned us into a police station," the judge exclaimed. The Supreme Court has declined to entertain a plea by the Sri Krishna Janmabhumi Mukti Nirman Trust seeking a scientific survey of the Shahi Idgah Masjid premises, which is claimed to be built over Krishna Janmabhumi. However, the court clarified that all questions relating to the Krishna Janmabhumi Shahi Idgah Mosque dispute would be left open for the Allahabad High Court to decide, which has recently transferred to itself several suits regarding the ongoing land dispute. The Supreme Court has dissolved the special investigation team established to investigate the October 2021 Lakhimpur kheri violence, which saw the deaths of 8 people, including 4 protesting farmers. For more context, the Lakhimpur kheri violence occurred amid year-long farmers' protests against the government's controversial farm bills. 8 individuals died during the clashes that were prompted by 4 farmers and a journalist allegedly being mowed down by a vehicle in the convoy of BJP leader Ajay Kumar Mishra's son, Ashish Mishra. In response, the Supreme Court had taken suo motu cognizance of the incident and constituted a special investigation team after concerns were raised about the initial police investigation. The court had also appointed former Punjab and Haryana High Court Judge Rakesh Kumar Jain to supervise the probe. This special investigation team completed its investigation and filed charge sheets in January last year. The court noted that the SIT's role had ended since the investigation was now pending before the trial court. It also considered a letter from IPS officer S.P. Shiradkar, who headed the SIT, detailing subsequent events. In view of these, the Supreme Court ruled that the SIT members and Justice Jain could be relieved of their responsibilities at this stage, but clarified that if the need arose to reconstitute the SIT or address related issues, appropriate orders would be passed. In the ongoing Adani-Hindenburg legal saga, one of the petitioners, Anamika Jaiswal, has raised fresh concerns in the Supreme Court about the impartiality of the expert committee appointed by the court earlier this year. This committee, formed in March and comprising 6 members, submitted a report in May, prima facie ruling out a finding of regulatory failure on the part of the Securities and Exchange Board of India in dealing with the alleged contravention of securities law by the Adani Group or any other companies. However, Jaiswal's affidavit now questions the suitability of 3 committee members. First is O.P. Bhatt, chairman of Greenco, who is flagged for Greenco's partnership with the Adani Group since March 2022, creating a potential conflict of interest. Second, concerns have been raised about the impartiality of Somasekhar Sundaresan, a lawyer who has represented Adani in various forums. Lastly, apprehensions have also been raised about K.V. Kamath, former ICICI Bank chairman, who is himself named in a CBI investigation related to the ICICI Bank fraud case. As a remedy, Jaiswal has sought the dissolution of the current expert committee and the establishment of a new one. It's also noteworthy that Jaiswal had previously alleged SEBI's conflict of interest in investigating the Adani Group just a week ago. You may remember that earlier this year in May, a Supreme Court Constitution bench delivered its verdict on the rift in Maharashtra's Shiv Sena party caused due to a coup carried out by a faction led by now Chief Minister Eknath Shinde that led to the fall of the previous Maha Vikas Aghadi government. Not only had the Constitution bench declined to order the restoration of the Uddhav Thackeray-led government, but it had also refrained from directly adjudicating the disqualification petitions of rebel MLAs in Shinde's faction, citing a lack of extraordinary grounds. At the same time, the Supreme Court had asked the Legislative Assembly Speaker to decide the disqualification petitions within a reasonable time frame. In July, the court issued notice in a petition by Sunil Prabhu, a member of parliament belonging to the Uddhav Thackeray-led Shiv Sena, seeking a direction to the Speaker to expeditiously decide the question of disqualification. For context, these pleas have been pending for over a year now. This week, the court expressed its disapproval over this delay and emphatically said that the Speaker cannot indefinitely postpone proceedings under the Constitution's 10th schedule. The court also cautioned that the Speaker must respect its directives. The Supreme Court has referred the 1998 P.V. Narasimha Rao judgment to a 7-judge bench. In this judgment, the court held that legislators were immune from prosecution in bribery cases related to parliamentary votes and speeches under Article 105 subclause 2 and Article 194 subclause 2 of the Indian Constitution. However, the court had specified that immunity applied only if legislators carried out the act that they received a bribe for. In other words, if a legislator took a bribe to vote for a candidate but later voted differently, the legislator would be disentitled from claiming immunity. The verdict was delivered in a case involving Sita Soren, a Jharkhand Mukti Morcha member accused of accepting a bribe for a 2012 Rajya Sabha vote. She claimed immunity under Article 194, subclause 2, but the Jharkhand High Court dismissed her plea, leading to the appeal in the Supreme Court. An important development from the Supreme Court involves the challenge to the extension of reservations for scheduled castes and scheduled tribes in the Lok Sabha and state assemblies. These reservations, originally set to last for 10 years from the Constitution's commencement, have been extended multiple times through constitutional amendments. In 2000, the 79th Constitution Amendment Act of 1999, which extended the reservation by another decade, was challenged in the Supreme Court. Again in 2019, the government introduced the 104th Amendment, which extended the time limit for SC and ST quotas, but discontinued reservations for Anglo-Indians. This amendment, which came into effect in January 2022, also prompted a legal challenge. The Supreme Court has now decided to hear the validity of the 104th Constitution Amendment Act. The matter is scheduled to be heard from 21st November 2023 by a constitution bench comprising Chief Justice D.Y. Chandrachud and Justices A.S. Bopanna, M.M. Sundaresh, J.B. Pardiwala and Manoj Mishra. This 5-judge bench will answer 2 questions: whether the 2019 amendment is unconstitutional, and 2, whether the exercise of constituent powers of amendment to extend the period prescribed for the expiration of the period of reservations under Article 334 is constitutionally valid. The court, however, has clarified that while dealing with the second issue, it will not assess the validity of previous extensions. The Supreme Court is set to begin hearing a series of petitions challenging the constitutionality of Section 6A of the Citizenship Act 1955, starting from 17th October. This section was introduced in 1985 as part of the Assam Accord, a pivotal agreement between the Indian government and leaders of the Assam movement. The accord aimed to address issues related to illegal immigration and protect the rights of the indigenous population in Assam, which had witnessed a significant influx of people from Bangladesh and other regions. Section 6A allowed individuals who entered India between January 1st, 1966 and March 25th, 1971 and were living in Assam to register themselves as Indian citizens. However, a Guwahati-based civil society organization challenged the section in 2012, alleging that it was discriminatory and arbitrary. They argued that it set different cutoff dates for regularizing illegal immigrants in Assam compared to the rest of India. The petitioners also requested the court to direct the authorities to update the National Register of Citizens by considering electoral rolls before 24th March 1971. The Supreme Court has rejected an application by a firecracker manufacturers association to include barium with improved formulations in green crackers, upholding its previous order banning the use of barium-based chemicals in fireworks. This decision comes as a part of a long-standing case initiated in 2015 when a petition sought a complete ban on fireworks during festivals due to their harmful effects on air quality and health. While the Supreme Court had ruled against a complete ban in 2018, it allowed only the sale of less polluting green crackers through licensed traders. In 2021, the court reinforced its earlier order against barium-based chemicals in fireworks. This week, the court clarified that these orders remain in force, disallowing barium even in improved green cracker formulations. Next, let's turn to some news from High Courts. The Andhra Pradesh High Court has dismissed the petitions by former Chief Minister N. Chandrababu Naidu, a leader of the Telugu Desam Party, to quash an FIR related to a multi-crore skill development scam case. Naidu was arrested in connection with this case on 9 September by the state's Crime Investigation Department. In his petition, he argued that the trial court's order remanding him to custody did not consider that CID had failed to obtain prior approval from the governor is required by Section 17A of the Prevention of Corruption Act. However, a bench of Justice K. Srinivas Reddy ruled that prior sanction from the competent authority was unnecessary for the investigation since the use of public funds, allegedly for personal gain, did not constitute an act in the discharge of official duties. The court also agreed that given the seriousness of economic offences, the investigation should not be hindered, especially at this early stage. The Delhi High Court has issued an interim order to safeguard the personality rights of Bollywood actor Anil Kapoor, prohibiting various entities including unidentified parties from exploiting his name, acronym AK, nicknames like Lakhan, Mr. India, Majnu Bhai, phrases like Jhakas, image, voice and other elements of his persona for financial gain without his consent. Personality rights encompass an individual's legal authority to control the commercial usage of their name, image or other aspects of their identity. These are often associated with celebrities and public figures, but they can apply to anyone. Kapoor's suit also sought protection against the misuse of his personality rights through technologies like artificial intelligence and deepfakes. Justice Pratibha Singh's order mandates the removal of specific videos from the internet and acknowledges the protection of free speech and criticism as long as they remain within legal bounds and do not harm an individual's reputation. In a development related to the 2018 Bhima Koregaon caste-based violence, accused tribal rights activist Mahesh Roth has been granted bail by the Bombay High Court. Roth has been in custody since June 2018 for allegedly having Maoist links. It must also be noted that the High Court has stayed the operation of the bail order for 1 week as requested by the National Investigation Agency, allowing them time to file an appeal before the Supreme Court. Who among those who grew up with social media hasn't heard a parent or an elder or a teacher saying that these platforms are rotting our brains? Now, the Karnataka High Court has also added to the conversation about social media addiction, suggesting that the union government consider implementing an age limit for social media use. During a hearing on an appeal by X-Corps, which was formerly known as Twitter, Justice G. Narendra noted that school-going children are increasingly getting addicted to social media. He proposed the introduction of an age limit similar to excise rules to address this problem. The judge also emphasized the need to remove inappropriate content from the internet as it can negatively impact young minds. This appeal by X-Corps, which is currently being heard by a bench headed by Justice Narendra, challenges a single judge bench's decision to dismiss its petition against blocking orders issued by the Ministry of Electronics and Information Technology under Section 69A of the Information Technology Act. An exemplary cost of Rs 50 lakhs was imposed by the single judge bench. Challenging that, X-Corps has argued that such high penalties deter intermediaries like itself from challenging blocking orders that violate legal provisions. The social media giant has also contended that upholding the single judge bench's decision would encourage the government to issue more blocking orders that infringe upon the IT Act, blocking rules and the safeguards mandated in the Shreya Singhal case. That wraps up this week's legal news roundup. But before I go, I have a little request from the entire LiveLaw team. We are an independent, fact-driven media organization that is committed to fearless and ethical journalism. To keep delivering your daily and weekly legal updates, especially in this dynamic audio-visual format, we need your support. So don't forget to do the Fantastic 6. Give our video a thumbs up, share it with your family, friends, classmates and your colleagues. Make sure you subscribe to our YouTube channel. Drop your thoughts and feedback in the comments below. Tap that bell icon to get your notifications, and lastly, swing by our website www.livelawmedia.in for our in-depth reports. I'm your host Ostika Das and I will see you again next time.